Hi, everyone. We will be starting shortly. Just letting everyone get in now. So give us about 1 minute. Okay, well, we only have an hour, so why don't we get going? Welcome everyone to the webinar today on key issues and buying and selling creative and technology businesses. I'm Brian Heidelberger, chair of the advertising group, and with us today we have Ronelle Porter, deputy chair of the Loeb Capital Markets Group, Lloyd Rothenberg, co-chair of the Capital Markets and Corporate Group, and Lisa Wiznitzer from the Advanced Media and Technology Group. Thank you all for joining us. If you are looking for CLE, a little housekeeping before we begin. This is CLE eligible. You'll see the CLE code at the end. The CLE materials for the webinar were sent in a reminder email this morning. So please make sure to look for those, fill them out, and then email the executed versions back to Leslie Garrison, whose email address, lgarrison@loeb.com, will be in that email that you received this morning, so you can get that all-important CLE credit. So I think that's about it. This is a 1 hour webinar. We encourage you to ask questions. You can type those questions in the Q&A at the bottom of your screen. We'll try to address them either during the presentation or at the very end. And if for some reason we don't get to them today, we will follow back with you. And of course, any of you are welcome to follow back with any of the panelists to follow up on any materials today or ask any follow-up questions that you have. So thanks so much for joining us today. And we look forward to speaking about this topic. It comes to us in an interesting intersection, in particular here at Loeb, because many firms have the M&A practices, but where it really comes to us often is in this creative field, in the entertainment field, in the technology field. And that's really because that is really what makes up Loeb and Loeb. The entertainment group here consisting of film and television and podcasts, the advertising group, our privacy and data protection group, our brand protection group, our technology outsourcing and ad tech group, our sports group, all of these things come together that really help us to facilitate these types of transactions for clients. And so when we are acting in this space, we're really doing two things. We're acting on an M&A transaction standpoint, but we're also acting as critical business advisors in each of these individual areas, because many of the partners here have been working in this space and they know not just the legal issues in the film and TV or AI or privacy and data security or advertising world, but because they practice so long, like somebody like me who's getting this old, been practicing for 30 plus years, I know the business issues that are involved in the advertising business, and we can lend that to these types of transactions. So these types of transactions, what am I talking about, just to set the table? I mean, there's obviously a myriad of those in the creative and the technology and entertainment world, but sample stuff that Loeb and Loeb is working on all the time is the advertising and sale of, sorry, the buying and selling of advertising agencies, of media buying agencies, media companies, production companies. Lloyd was just telling me that he just did a big film library sale. Advertising technologies and other just pure technology business, often which come up in the SaaS space, in the data analytics space, in the e-commerce space. Those are all of the types of things that we lend our expertise to all the time, and the type of technology and transactions that we're going to be talking about today. So I think I'm first going to turn this over to Ronelle, who's going to give us a little bit of an overview.
Thank you, Brian, and welcome everyone. I'm going to start my portion here, and assuming that I'm not speaking to deal lawyers. Um, you know, but rather to people who are involved in creative and technology businesses and whose roles may touch an M&A transaction. So hopefully as we go through kind of what that process is, you'll be able to identify or hear where you and your particular sweet spot in a company or in a department may actually touch some of these various steps along the way, and thinking how might you be of assistance, or how might someone call on you to assist in the process, even if you're not the actual deal lawyer. So yeah. And for the deal lawyers, I apologize that this might be a little granular, but still going to keep it very high level. Like an M&A transaction looks generally the same across the board, regardless of the industry. It's the industry that makes it, for me at least, really interesting. And those are that's what brings the nuances to the process. As you'll hear from my colleagues as we go through, it's really, depending on the industry, you'll need to focus in on certain things in certain areas versus others. But in terms of just before we even get to sell or buy side, the process, each transactions generally have the same structure. You're talking about a pre-sale process, and that, we'll talk about what that looks like from the buy side and the sell side. You're talking about actually engaging with buyer or seller. Once you've done that, it's the kind of let's find out about each other phase, and whether or not we want to continue along this road. So that's your due diligence. And then you kind of have, okay, so we do want to go forward. And sometimes these happen, in tandem. You're also negotiating that definitive agreement. Once that's done, you're kind of in that you can have a sign and close, or you can have a signing with a closing to follow, a subsequent close. You close, and then you have all of your post-closing fun. Now you own the business and what. But we thought we'd take a minute to really, if you're on the sell side, if you're selling one of these type businesses, kind of your process, and if you're buying, and there will be some overlap. So to the extent that our slides say the same thing, because buyer and seller will be engaging in a lot of the same processes, we won't stay too long on those. But from the sell side, first you're deciding, we want to sell our business. And, there are a lot of reasons why a company in this space may engage in a sale transaction. And it may not be a full sale, it can be a minority sale, it all depends, but some form of a corporate M&A transaction. It could be that you have come as far as you can in the process of what your business allows for your infrastructure, your clients, your staff, and really needing that next step and that partner to take your business to the next level. And you're thinking about this, and it just seems like the right time and the right fit. You could be looking to just exit. You've been at this long enough. We see this a lot with some of these businesses, and a lot of them, mainly your pure tech businesses. They've been in closely held companies, family-owned businesses, or just two college buddies who years ago decided to do this. They've been really successful at it, and maybe you don't want to exit completely, but you want some liquidity. And then there's, of course, the complete exit, where you're going to sell the business, you're going to walk away, and you will no longer be engaged. And if you are, maybe it's for a short period of time through an employment or transition services agreement. But so once you've gotten to that point where you want to do this, then you need to engage your advisors. Lisa, can we go back for a second? Because I think this slide will probably help that process along. But at least for the first two steps, you want to engage your advisors. Who are your advisors? Depending on what you want to do, you may want a banker to run a process. And if you can, to help you engage with bidders, identify certain, be it a financial bidder, are you selling to PE? Are you selling to someone who's in it for a pure financial play? Or are you looking for a strategic buyer where you want to continue the business? Because really you're looking for that growth. You just need a bigger platform, either through more so the monetary investment, or really to partner with a strategic where you are filling a vertical that they're missing, and or they're helping you expand on something within the company. And then there are the lawyers that, and here's where I do the plug for hiring your lawyers early in the process, especially when you're on the sell side. And I say this not because I'm a lawyer, but because from years of experience thinking about sometimes being brought in later in the process on a sell side deal, and you're thinking of all the ways you could have been more helpful up front if we were engaged to kind of help to set that seller up for success, or an easier process along the way. A lot of times, and you'll see in terms of the steps, just doing some housekeeping, which I would advise, especially in these spaces where you have a lot of things. You may have a lot of agreements, independent contractor agreements, talent agreements. There's just a lot of what we like to refer to in the corporate department as stuff. And you have all of that, and it's all about how that's packaged and presented to your buyer. And I say this because I think it's really important to present, especially in this space, a more formal presentation of the corporate self and structure, because I think buyers are going to look at that and they're going to have all these questions, but they're going to, it always, when I'm on the buy side, I tell my clients, look, they're really organized. They have all their stuff. They know what they're doing. They're able to answer questions pretty quickly. And that gives the seller a lot of credibility. And so buyers engaging with a seller who has things together the process itself can go a lot smoother. You can go to the next slide, please, Lisa. Yeah, so we can talk about just that, what you were doing in terms of preparing, what I was just talking about, getting yourself ready to be sold, and not waiting for the buyer to ask you those questions. And once you have your banker in place, if it's an auction process, they're going to go out and they're going to help you identify those buyers. If no auction, it depends on were you approached by someone, by a potential buyer, because sometimes it's not always a process, right? You are doing great in the marketplace, your name keeps popping up, there's a strategic out there who thinks that you're a great fit for them, and they may approach you, and the price is right, the synergies are right, and so it makes sense for you to come together and explore a sale process. Once all of that has been, and you've identified each other, you're entering into a non-disclosure agreement, an NDA, making sure, especially in this space with such proprietary information that's going to be exchanged, not only in the hardcore diligence phase, but in that preliminary phase up front of, do we want to go forward, and what is our bid going to be based on this preliminary information that you've provided? And hopefully some of this you wait a little longer to disclose, but you'll be giving a lot of business specific, trade secrets, confidential information up front. So you want to make sure that you do have that NDA in place with any potential buyers, all of your advisors. Once you get to that phase, then you're gonna diligence and your definitive agreement sometimes are running side by side. I think long gone are the days where it's you do diligence for 45 days and then you come to the table and we start doing, we then start drafting the agreement. I was just at a conference where one of the panelists who is in this space said, how can you make these agreements shorter? I'm speaking out to the lawyers, and the time frame much more condensed. So speed matters, doing it right matters, of course. But in these businesses where things are changing, and such sensitive information is also changing hands, you want to make sure that process is tight and that it happens fairly quickly. So you're looking at diligence and the negotiation of your definitive agreement kind of working hand in hand. On the sell side, this is where you're going to be probably the most frustrated as a seller or within a selling organization. And this is where that kind of pre-planning process is helpful. It's where you're gonna have two roles. You're gonna be continuing to create value in your company by doing your day job and making sure that you're paying all attention to all the things that kept you busy for 27 hours a day. Yes, there aren't 27 hours in the day, but all the things you're thinking about as you're sleeping. And then we're going to throw in the process of being responsive to a buyer through the diligence process and gathering things, but still trying to do all the things that you've done before. And so for a lot of folks on the call who may not be specifically engaged in the process of drafting the agreement or doing things, you may start getting requests for documents. And if you're not necessarily, and that's the other part in terms of who do you let know that this process is happening? So that they're brought in so that you can be responsive to the buyer, because that's what they're going to want. Once again, building credibility, but also not sending everyone running for the hills if they're thinking that you're selling, and job security and all of the things that come along, and the uncertainties for your personnel. So you might start getting requests for documents. You might start seeing a lot more foot traffic through the organization as there are management meetings and other things going on. So, if you are that person who's brought in, just, one thing is, I would say, though you're being asked to collect documents, just be mindful of running those documents through a process first in terms of what should be disclosed and at what stage. Because you don't want to inadvertently give things with sensitive information, formulas, contracts, etc., out too soon. And I believe, Lisa, you're going to be talking about the diligence process and kind of how you do that later on. But that's just one of the things as you're in this process and you're being tapped to be helpful. If you can go to the next slide, please, because I think a bunch of these things, sorry, the next one as well. If you look here, you'll see a lot of overlap in terms of these two slides. So from the buy side, you're looking at preparing, you're doing the same things, right? You're engaging your advisors. First and foremost, you're figuring out what is your need. What type of buyer are you? If you're a PE firm and you're looking to just do a pure financial play and you're looking for companies that you may not think are managed well, or you can have a great impact if you have the right management team in place, the right resources, the right platform to grow it. You're looking there for more of a financial play. If you're a strategic buyer and you need to, once again, like I said, on the sell side as to why someone might approach you, you're just trying to fit a missing piece and double down on certain synergies with the company to boost your own existing platform. These are the reasons from a buyer side. You're looking to acquire talent, technology, data, just expand your market share. Those are the things that you're considering, and that may make you approach a seller who's not running a process. You go through your initial contact, and you may also hire a buyer to, I'm sorry, a banker to look for these opportunities for you, right? It's not only sellers who hire bankers. The negotiation and diligence, that's a period that both shared by the buyers and sellers. It just looks different. On the buy side, it's information gathering. You are looking to really figure out where the holes, right? Where are all the great things? Where do we think some of these you're thinking, not only, at least you should be thinking, not only the immediate process of where did these things that we're finding fit into a definitive agreement, into a purchase agreement? How do we bolster? Where do we need our protections? But also as you're as parts of your management teams are looking at certain agreements and different arrangements, how do those fit in post-closing? How can we think about those in our larger, platform, and how can we utilize this? You're already, hopefully, you're thinking post-closing already. And if that's a shared process, then by the time you get to post-closing, you should be a well-oiled machine, at least having explored some of those things through the diligence process. But so then you have a definitive agreement. Like I said, it can be a sign and close, meaning you're signing and closing on the same day. You're gathering all of your approvals and third-party consents. And if you have, depending on what those are, some may have, depending on at least the structure as well of the deal. Is it an asset purchase of the way you're acquiring the business? Is it a merger? May cause more of these type third-party consents. From the buy side, if you need to get financing in order to, pay the purchase price, then that should be working. Usually that's what's happening in that period between sign and close. So the buyer and sellers are working on different things during that process, but ultimately both are trying to get to the end place where they satisfy the various closing conditions and the transaction can be closed. And then of course all of the post-closing stuff that will happen once the transaction is consummated. I think I am definitely at time to give everyone else an opportunity to take you through now more of the nitty-gritty of how do these businesses blend into this process? How, I think in my talking, I've hit this slide and the other one in terms of key considerations. So I'll now turn it over to Lloyd Rothenberg, who will go into the considerations for these specific type companies.
So Ronelle, thank you very much. Lisa, if you could go down to slide 13, key consideration transaction structure. Perfect. That's where I'd like to start. And as Ronelle said, I'd like to dig in a little bit deeper in a number of areas. And while we certainly see lots of deals where the purchaser is buying 100% of a company, seller is selling 100% of the company, especially when it comes to creative businesses, we oftentimes see a structure where only a piece of the business is being sold, and oftentimes it's only a minority interest. To the extent that there is a rule of thumb, we'll see something like 25 to 35% of that creative business sold up front. And there are a bunch of reasons for that. From the purchaser's perspective, it's a smaller initial check. It also gives the purchaser a lot better perspective about the business before they have to invest more money to purchase additional interests in the business. It, of course, gives them the ability to effectively pay over time without an interest charge. But from the purchaser's perspective, or maybe if you want to look at it from the seller's perspective, the value of the interests that are sold over time could be significantly more than the value paid up front if the business does perform. And certainly we've seen many situations where businesses have really hit it out of the park, and the amounts that were paid to purchase the unpurchased interests in the business have been very, very significant amounts. One of both the challenges and really to some extent the administrative challenges of buying a business in increments is not only do you need to enter into a purchase agreement upfront with all the bells and whistles that go into that, but you also need either a limited liability company or a stockholders agreement, which governs the business going forward and also governs how additional interests get transferred from the sellers to the buyers. And we typically see three different ways in which the balance of the business gets purchased. Typically, we see either an event-based call option. We'll come back and talk about what that is. We see a time-based call option, and in some deals, we also see put rights. Now, these are common themes. Every deal is going to be a little bit different. Typically, the party that is purchasing the additional interests is not the business itself, but it's rather the original buyer, whomever that may have been. So what's an event-based call option? Typically, the purchaser will have the right to purchase some or all of the remaining interests in the business in the event that certain people, typically the sellers, oftentimes they are the founders of the business, their employment terminates. And it's regardless of the circumstances of termination, whether they leave for good reason, whether they're fired for cause. We'll talk about what impact that has on price. But regardless of how or why they leave, the buyer has the right to purchase the remaining interests in the business. The second way that we see folks have a right to buy the additional interest is over time. And an example, which is in the materials, is after some period of time, after audited financials have been delivered, the buyer can buy more interests. Now, for example, maybe let's assume they own 35% up front. Maybe after the second anniversary of the closing, they have the right to buy an additional 25%. After the third anniversary, more. And then even if they've not exercised those call options at all, then at the last time period, they have the right to buy up to all of the remaining interests in the business. And oftentimes that's triggered off of the delivery of audited financials, because that's going to provide EBITDA information, which we'll get to later, which is oftentimes the way the purchase price for these particular interests is determined. The third way, as I mentioned, is a put right. Now, put rights are not in every deal. They are very highly negotiated. To the extent that they exist, they are typically held by the founder or the seller of the business. And when they're granted, they're usually going to be conditioned on something. For example, the business has to have performed at a certain level. An example would be EBITDA of $5 million for the trailing 12 months before the founder can trigger the put right. And that's obviously so that the buyer knows that the business is succeeding. Another condition that we regularly see when put rights are granted is that the founder, in connection with exercising the put right, needs to extend their employment term. Maybe it's on the same terms as in their existing employment agreement. Maybe they're going to be enhanced terms. But that's going to be part of it, because especially in a creative business, when the founder is such a key piece of that creativity, we want them to be on longer when we're buying more interest from the founder. And oftentimes it also comes with the founder needing to agree, or the put holder needing to agree that they will extend any restrictive covenant periods, whether it's a non-compete or a non-solicit, the buyer knows that they can be protected for that additional period. Finally, we oftentimes see that the founder may need to make representations and warranties about the business that's being sold so that the purchaser has comfort that nothing out of the ordinary, if you will, has occurred. Lisa, if you could go to the next slide.
Yeah, and I think, Lloyd, just to build on that, I think, right, especially in the put right scenario where you're talking about creative individuals who have a lot of knowledge and a lot of relationships, oftentimes, right, their extended involvement or their extended restrictive covenants is often even more important in these types of businesses, such that that put right, it can be used strategically in order to, keep them involved in the business for a period of time and ensure some future success given these types of businesses that are maybe not as cut and dry as some others.
Completely correct. That's an excellent point. Thank you. So on this next slide, we talk about a bunch of things. The first is, what does the form of consideration look like when a business is bought or sold? Well, not surprisingly, cash is going to be one of, and maybe the most important component. To the extent that there's a rule of thumb, we oftentimes see that cash will represent 60 to 70% of the amount paid at closing. An earnout is also typical, by the way, regardless of whether we're buying all of the business or part of the business. Earnouts, again, to the extent that there's a rule of thumb, will typically be in the 3 to 5 year range. That's the measurement period. And to the extent it's going to be in the longer zone, in other words, the 5-year zone, there may be a payment in the earlier year, which is in effect the deposit, if you will, on what gets paid after the 5-year period. Sometimes we see a seller note. For example, the seller will basically take back a promissory note issued by the buyer. When a seller will take back a note, it's typically subordinate to any other debt the buyer may have. It will oftentimes require current payments of interest on a quarterly basis, for example, and oftentimes the principal of the note is not payable until the end of the note, which could be, for example, in the most recent deal that we're looking at a term sheet, we represent the seller. The buyer is looking for a balloon payment at the 6th year. We're trying to pull that back to an earlier period, but you get the idea. And then another form of consideration is the seller may take back equity in the buyer and become an owner of the buyer. Now, that tends to be a smaller piece of the consideration. Again, to the extent there's a rule of thumb, something in the 10 to 20% range of the value. The seller will then own a piece of equity of the buyer. They typically do not have very many rights other than to be paid when the buyer is ultimately sold. And sellers will typically try to negotiate a put right for that equity so that on certain specified occurrences, they have the right to get paid out. That's difficult to get, but certainly not impossible. When we're in a position where we've bought 25 or 35% upfront and we've got puts and calls for the balance of the business, oftentimes the purchase price for the exercise of the put or the call is determined either based on EBITDA or EBIT. Usually it's looking at the trailing 12 months. Sometimes it's more complicated and it might look at the average EBITDA over the prior 2 to 3 years. When we're talking about average EBITDA over the prior 2 to 3 years, then typically the most recent year gets more heavily weighted than the earlier years. In situations where, and you saw we talked about event-based call options, that applies regardless of the reason for the termination of employment, but with some very, very different and sometimes dramatic differences in price. For example, someone's terminated for cause and the buyer then exercises their call right, whatever the formula is for determining the purchase price might be discounted by up to 50%. So in effect, You could look at it two ways. The buyer is getting a bargain, or you could look at it and say, wait a minute, one of the most important people is no longer there. And so by definition, the business must be worth less, and therefore the buyer should pay less. In situations like that, the definition of cause, not surprisingly, is very, very carefully negotiated. In situations where someone's terminated without cause or they leave for good reason, then maybe no surprise, there's no discount, just whatever the formula would produce. Those call and put price variables oftentimes see higher multiples as the cumulative EBITDA of the business increases. And this can get very complicated. We've had deals where there are 8 levels of multiple. For example, starting with a 6 multiple at a particular level and going up as high as almost a 9 multiple at the higher end of the range. But those higher multiples only apply on the additional EBITDA. So to take an example, if you had $1 of EBITDA, the 6 would apply on the first dollar. The 6.5 multiple would only apply on the EBITDA between $1 and $1.50, and then go from there. We also see, and my understanding is there may be an accounting reason for this, that there are potential overall caps on the amount paid for the puts and the calls, meaning regardless of what the formula might generate for the exercise of the call, the seller has agreed that the maximum amount the buyer needs to pay overall upfront cash plus the puts is X dollars. You know, we've seen numbers as high as 150 million. Obviously, those are going to be very deal specific based upon the performance of the particular target company. Lisa, could you go to the next slide? Okay. So how does the put call price get paid? Maybe not surprisingly, the most common way, especially when it's on the call side, is that it's a lump sum at closing. Price is determined. There are very detailed mechanisms on how you exercise, on how the price gets determined. Oftentimes, the seller has the right to contest it, and then there's a dispute resolution mechanism. Once it's been agreed upon, cash, changes hands at closing. We do see in the context of a put right, more often than not, it's paid over time. An example would be 25% at closing and the balance in some increments, whether quarterly or annually, over some period of time. Again, to the extent there's a rule of thumb, then those are going to be in the 3 to 5 year range. The note is never a secured note. It's always an unsecured note, and it's always subordinate to any other obligations that the buyer may have. Regardless of whether, when we buy a piece up front, there are always going to be drag along rights and tag along rights, so that when the balance of the business gets sold to a third party, no one's left at the altar. You'll see, and we'll get to this a little bit later, there'll be a right to appoint managers. So let's assume that the buyer has bought 25 or 35% of the business up front. Let's assume there's a 5-person board. Typically, the buyer would have the right to appoint 2 of the 5 directors. The sellers, since they're still the majority owner, would have the right to appoint 3. Then when it flips and the buyer has now exercised call rights, or the seller's exercised a put, and now the buyer owns more than 50%, that'll flip. And the buyer will have the right to appoint 3, and the seller will have the right to appoint 2. In the same way, and we'll get to some examples of this later on, when only 25 or 35% is purchased up front, then there are going to be a whole long list, which will be very highly negotiated, of actions that require more than just a majority of the board, so that each party can be protected. And oftentimes, who holds the right to approve the significant actions will also flip. So the buyer will have while they're a minority owner, and then the seller will have similar or identical rights when they're the minority owner. Lisa, if you could go to the next slide. So let's see. So the strong preference for every deal, and Ronelle talked a little bit about this as well, is that we sign and close simultaneously. Sometimes that just isn't possible, either because we need regulatory approval, and we'll come back to that because you might be surprised how oftentimes regulatory approval is needed, or because there are material contracts that are valuable to the business, and there are change of control provisions which would otherwise give the commercial counterparty the right to terminate, and we want them to approve of the deal. So when might there be regulatory approval in a way which might not sort of jump out? Well, we've had situations where a non-US investor from, by the way, a country with whom the United States has excellent relationships, buys a minority piece of the business, a significant minority piece, but that business has access to all sorts of personal information, including PII. And as a result of needing to make what's called a CFIUS filing, we then were in a position where we needed to negotiate something called a national security agreement, believe it or not, with a bunch of different branches of the federal government, even though the investor was a minority. It was a big minority, but still a minority. And the investor, by contract, had no access to that information at all. It took about 6 months to negotiate that agreement. The agreement imposes a significant number of administrative requirements on the target. And as you might imagine, when you've got a significant number of administrative requirements, there's a lot of cost that goes into complying with those kinds of agreements. Now, I'm not trying to scare you away from doing these deals. All I'm suggesting is it's something that needs to be monitored so that you can manage the process. Lisa, could you flip to the next slide?
Yeah, Lloyd, I think another one, here that's also particularly important is right when we're selling a piece of a business, whether it's an advertising agency out from a holding company, whether it's sort of a silo of a technology services business, there's often some type of back-end services that are being provided where a type of transition services for some of those affiliate services that are being provided is really important. And you understand part of that during diligence, but sometimes that's what sometimes that's also what triggers the need for a staggered sign and close in order to sort of work out the mechanics or potentially fully transition the business from those shared services to sort of a standalone business, particularly in a holding company agency scenario or other types of similar instances. So just wanted to get that in. But
yep, also an excellent point. Okay, so how are earnouts computed? And I realize I'm running out of time, so I'm going to try to pick it up a little bit. Infrequently, they're computed based on revenue. Almost always, they're computed based on EBITDA. This is oftentimes a highly negotiated definition. I've seen EBITDA definitions go on for 2 full pages, single-spaced. Oftentimes based upon the buyer's accounting principles. And when you think about a strategic large corporate as the buyer and the creative as the seller, then there may be very significant differences in the way that the seller accounted for things and the way the buyer is going to want to account for things. Also, a whole bunch of special rules can get negotiated. Maybe what I'll do is jump down to the last one, because in my mind, it's a great story and it's a great example of how people can be creative. So we inherited a deal from another firm, and in connection with an earnout, counsel for the buyer tried to argue that the price paid for the earnout should be deducted in computing subsequent earnouts. And you're probably saying, Lloyd, that makes no sense. Well, I don't want to tell you what we said. We were very polite in our conversation with the buyer's attorney, but as you might imagine, we weren't letting that one go away, because it, in addition to just being wrong, it would have significantly reduced the amount paid to the sellers whom we represented. So the lesson that we learned, and when we put this in our agreements, people sort of look at us and think we're crazy. We now add to all of our earnouts, when we're on the sell side, a specific statement that says that, you know, the price paid, whether it's for the put, the call, the earnout, is not deducted in terms of computing the price to be paid to the seller. What this shows you is you need to very carefully think about how to define EBITDA, whether you're on the buy side or you're on the sell side. And you see a bunch of examples here of things that are industry specific, like format license fees, which the target company may be paying, but may not be taken into account when you're determining the amount of the earnout. You also see a lot of negotiation over management and overhead fees, which certain of our clients have referred to as nothing more than land grabs, and then internal charges, which, you know, may be legitimate services, but you want to make sure that you're getting a fair price for those services. Lisa, let's flip to the next slide. Okay, there's a tension when you have an earnout. Buyer, let's assume they bought 100% of the business, wants control over the business they just purchased, and this is whether they bought 100% or just a piece, but the seller wants to achieve an earnout. And so there are a number of different ways to try to balance those two tensions. One is for there to be, and you see this on the first page, management authorizations. These are the things that whoever's going to be running the business, oftentimes the founder, post-closing, can do without needing the approval of the buyer. And you see a whole bunch of things which gets into, for example, deficit funding caps or certain positions, entering exclusivity agreements, entering into agreements that have key person clauses. All of this gets negotiated so that the seller has a comfort level that they will be able to achieve their earnouts. Some of these get very detailed. For example, we have a deal where one of the attachments to the purchase agreement is a 3-page list of production companies and parties, networks, that the business is authorized to do business with without getting the consent of the buyer. So it can get very complicated and very detailed. Lisa, if you go to the next slide. Another way that this gets dealt with is by requiring that for certain significant company actions, and we've listed a bunch here, if the target company wants to engage in these actions, then the sellers, for so long as the earnout is outstanding, need to approve. Might be a sale of assets, it might be material changes to the business, certainly is going to be related party transactions, so that there's some control over how much money is flowing to the buyer through these related parties, deals. There might be a list of certain positions, whether it's the chief technology officer, the chief creative officer, the chief revenue officer, that can't be fired without the seller's consent. Certainly agreeing to restrictive covenants. We oftentimes see if the seller wants to make a material modification to a material contract, there might be an exception for terms of trade that are applicable to the entire group if it's a big corporate conglomerate that's buying the company. But this is also very carefully negotiated so that the seller has that comfort and the buyer still has control over their business. Lisa, can you go to the next slide? Thank you. So real quick, what happens or what happens in the event that the buyer wants to fire the founder, or the buyer wants to breach something or do something that the founder has an approval right over? Typically, the resolution of that is that some or all of the earnout has to be paid immediately. From the seller's perspective, of course, they want the maximum earnout paid because they haven't had the opportunity to actually earn their earnout. This also becomes very carefully negotiated. We've oftentimes seen situations, which is the third bullet on this page, where when the purchasing company gets sold, the selling company, if it's not 100% owned, or the former owners of that company, have the right to tag along and get the multiple that the bigger company is getting for the sale of its business. It really gives them the benefit of being part of a much bigger organization than what they were originally part of. And with that, Lisa, I will turn it over to you.
Great. Thanks, Lloyd. So in this next sort of part of the presentation, and to round us out, I want to talk about some of the specifics that might arise during the due diligence process that inform a lot of the other decisions that are being made, sometimes around the earnout, sometimes around some of the other financial provisions, and certainly around some of the legal representations and warranties that are within the agreements that are a lot of legalese, and also have a really big impact on sometimes the value of the business for the buyer. And likewise, some of those protections that you need going forward if you want to, have some continuity of business, particularly in some of the creative, whether production company sales or advertising agency sales, where they're really dealing with sort of a core team of people that matters a lot. So during the due diligence process, a key thing that you would look for in these businesses, where you might not be paying attention to it as much as in others, is really making sure that all of the intellectual property that it uses or claims to own is actually owned. Making sure that the licenses that they have either coming in or going out of the business really allow you as a buyer to do what you want to do with this business going forward. Or making sure that the value, let's say you're a production company, and you own, they're telling you that you own the IP of the productions, the creative that you create, and then you give your client a license to use it in perpetuity, right? You want to make sure that that's actually true, and that's something that you're honing in on. In a technology business, you want to make sure that you have the right, proprietary information and invention assignment agreements, whether that's from employees who are creating, technology for the business, whether that's from, independent contractors and making sure that they have those proper work for hire language in their agreements. Again, it all sort of relates to the value of the business that you're either buying and, the continuous nature of it going forward, whether or not it has what you think it has. Another thing that you often see in these businesses that you might not see in others, particularly on the creative and entertainment side, are key person provisions in agreements, which means that, the client might have approval if a particular individual is no longer working on their business. For example, something like that could have a huge impact on the business going forward if that's one of the individuals that maybe might leave following a sale, or is actually, certainly exiting as part of something. If they're the founder of, that advertising agency, for example, or production company, that may have a huge impact on that client relationship going forward. And then, likewise, you really want to think strategically about when part of a diligence process you actually talk to a business's clients or vendors. On the sell side, those relationships are really important to you, and you don't want them to necessarily know that you're selling before the deal is done. And on the buy side, you want to make sure that the revenue coming in from those parties or the services that you're getting from those parties is probably going to continue post-close, given that that's a huge part of the value that you're buying in those cases. And that is often the case in advertising agency client agreements, media buying agreements, for sure. And on the, on the technology side, vendor agreements, if they're a critical component to making sure that the business operates as it does, so that you're getting the value that you're getting. But really making sure that those are happening at a specific time, and that and as a seller, that you're being really thoughtful about when to make those introductions, so that it's not too early in the process to potentially jeopardize those relationships. Other types of sort of unique diligence issues that come up in these types of transactions, legal compliance from an FTC standpoint, consumer protection, things that, right, you wouldn't necessarily normally be thinking about in these types of creative and technology businesses, especially if there are consumers involved on one end or another, are things that you want to be thinking about. From an employment agreement perspective, if there are key individuals with key knowledge about the business, making sure that those are sufficiently protective from both a restrictive covenant perspective, making sure that, there's either a non-compete for a period of time or a non-solicit. Sometimes those I've been involved in a number of transactions where the key management has to enter into new employment agreements as part of the transaction to make sure that, again, some of those key restrictions are in place that really give the buyer enough protection going forward. And likewise, a technology specific issue that comes up a lot is the use of open source software. From a seller perspective, there's often, a representation in a purchase agreement that you want to do your own due diligence to make sure you're properly disclosing if something has open source software. And from the buyer perspective, open source software is obviously not as valuable to you as proprietary software, since it's available to more people. So that's something, right, from the buyer perspective, just really making sure. And quickly, although this is not normally a slide that can be done quickly, there's so many issues these days on data and privacy, particularly with the expanding nature of state laws. There's a lot of work to be done in this on the sell side and the buy side. Really understanding the information that you have or that you are about to get, and making sure that you understand sort of the data what you're doing with it and the data out, to make sure that either the business that you're buying or selling is properly protecting the data that it has. And this is something that, we advise anyone, but it usually comes up, and some deficiencies oftentimes come up during an M&A process that then on the sell side you try to remedy, so that you can make a representation in an agreement and also continue to get sort of your buyer comfortable. And on the buy side, really understanding the data that you're going to be getting and what you're going to have to comply with. There's a new issue recently that goes into effect on January 1st, 2025 in California, that impacts sort of the handling of consumer opt-out preferences, in particular in M&A transactions. It's an amendment to the CCPA, the California Consumer Privacy Act, and it requires acquiring businesses and M&A deals to honor consumer privacy preferences. So that would be opt-outs for data sharing or sales that were established by the original company. And it applies to mergers, acquisitions, bankruptcies, or other transactions where the control of consumer data changes hands. So that's sort of just a short tidbit that shows that there may be a gap in some cases between, what the law requires and what's possible from a technical perspective, and the question of sort of who takes liability there if it's not possible. A lot of issues that really come up around this data and privacy issue. Ronelle, do you want to take it back to close it out? I know we're out of time, or do you want me to zip through these?
You know what? You can completely continue going through them, because I think we can wrap it. We have 2 minutes.
Lisa, why don't we give everyone the CLE code?
Oh.
You will receive a copy of the recording as well as a copy of the deck after this, so you will have all of this information. If you're looking for more information on the CCPA law that Lisa just mentioned and how it applies to M&A transactions, you can look on my LinkedIn because I just put out a video this morning that's 2 minutes that gives you more detail on that. Just a little plug there. I don't know that we have time to go into any more of these slides, but we appreciate everybody's time. If you have questions, feel free to reach out to Ronelle, to Lloyd, to Lisa. Of course, we are available to answer any questions you have. So we appreciate everyone's time. We've hit the 1 o'clock hour and we want to keep you on our schedule. Thank you guys all so much for joining, and look for that email that was sent again this morning if you're looking for that CLE. Thank you very much.